Tonight, new developments in the Attorney General's case against a South Florida real estate company accused of deceptively locking homeowners into 40-year contracts.
10 Investigates Emerald Morrow has been tracking this for 2 years now. MV Realty wants a local judge to backtrack his ruling against these contracts.
Yes, but the judge is not having it. He denied the motion, giving the Attorney General's office a win in a case homeowners hope will soon bring them some relief.
$9,894.
It's what Barbara Jones of Sarasota is now having to pay South Florida-based MV Realty to get out of a contract she didn't realize would act like a lien on her home.
That is very frustrating, but if that's what it's going to take for me to break the agreement rather than waiting for X number of months or years for the Office of the Attorney General to figure out how to protect homeowners, I'm just going to do it.
For more than 2 years now, the state attorney general's office has been in a tense legal battle with MV Realty. A lawsuit accuses the company of, quote, swindling consumers out of their home equity. And it's impacted thousands of homeowners across the state who signed up for MV Realty's homeowner benefit program in exchange for a few hundred to a few $1,000s worth of cash. A signature gives the company 40-year exclusive listing rights. The agreement then gets filed on your property record. The AG's office says it's basically a lien.
The memorandum of homeowner benefit agreement serves to tell the public about these obligations, thus effectively acting like a lien and stopping people from being able to close their home transactions.
For Jones, it meant a roadblock to accessing home equity.
I was looking into a program with Unlock, which is a home equity agreement process. They pulled my property records and it came out clean except for this one piece.
This month, attorneys for MV Realty filed motions asking a Hillsborough County judge to undo a previous ruling that stated the homeowner benefit contracts are, quote, unconscionable and thereby unenforceable. The judge denied their request. MV Realty called the ruling unfair, saying, quote, this court has been misled by the plaintiff and taken their arguments at face value, and that there's, quote, no excuse for the miscarriage of justice that has taken place here to the extreme detriment of my clients. But those like Jones say the real injustice is against homeowners tangled in these costly contracts.
I want the peace of mind and I want them off my title.
Experts say to avoid having them there in the first place, make sure you check everything before signing any agreements.
What these people who are knocking on the doors are representing and what's actually in the agreement may be two different things. And that, I think, is where, when you're given the actual document, have that reviewed. Don't rely on just what you're being told. Actually read it.
Emerald Morrow, 10 Investigates.
It is unclear when the state's case against MV Realty will wrap up, but the state hopes the court will force MV Realty to clear people's titles. Other attorneys general across the country have sued to do the same. To read more about this case, head to 10tampabay.com/10investigates.